you go. You keep your seats. Okay. All right, if we have Mr. Paschel, please. This is the State of Tennessee versus Geoffrey Ian Paschel. It's docket 116806. Mr. Paschel is here with his counsel. The state is represented by the District Attorney General. Is the state ready for sentencing?
Your Honor.
Defense ready for sentencing?
President ready, Your Honor.
All right, General, call your first witness.
Your Honor, I think we have a preliminary matter if we can take up before.
Sure. Yes, sir.
May it please the court, yesterday evening we were given a email/statement from a potential witness at this sentencing hearing, Miss Allison Moon. Miss Moon apparently is a ex-wife, and Mr. Paschal and she share a child together. It is our position that her testimony, one, she is not a victim under the Tennessee Human Rights Act. The state is seeking to introduce this testimony as an aggravating factor. Tennessee law is clear in the fact that it is not clear on the issue of criminal behavior. Basically,
What is not clear on the issue of criminal behavior?
well, we would cite the court to State versus Carrico. In there, in terms of determining whether it is an appropriate aggravating factor from the state, it has to be a prior criminal offense or constitute criminal behavior. The Supreme Court...
What's the citation on Carrico?
Carrico is 968 Southwest 2nd at 280.
Does I have a copy for the court?
Yes, that'd be helpful. Thank you. Thanks, John.
And at Carrico, at page 285, the Supreme Court addressed the issue of whether being merely arrested or charged with a crime is not criminal behavior within the meaning of the statute. The court goes on to opine that the phrase criminal behavior has not been defined by this court for purposes of the enhancement factor. The court further went on to opine that whatever the precise definition may be, sexual acts with a 10-year-old child clearly constitutes criminal behavior. When you juxtapose the holding or the dicta of the court in Carrico versus the statement of Ms. Moon, it is clearly not subject to being an aggravating factor that would be appropriate under Tennessee law. The statement, and may I mark this and present it to the court for ID?
What is that?
The email that we received last evening from Ms. Moon.
Any
Ms.
objection?
Paschal from...
No.
Be received as number 1 for ID only. What is the holding in Carrico?
That the issue of criminal behavior has not been defined, but in this case, it could be an aggravating enhancing factor because it was allegations of sex with a 10-year-old child.
Okay.
May I approach?
Oh, yes, sir. Thank you. Go ahead.
In the email that's been marked as Exhibit 1 for ID, Ms. Moon goes on to relate a series of conduct that go back to the year 2007. Clearly, the allegations do not rise to the level of criminal behavior that would be an appropriate enhancement factor as set forth by the Supreme Court in Carrico. There is talk that Mr. Paschal pulled her hair and frustrated her during her honeymoon, then alleges that he dragged her by the hair, squeezed her mouth. It goes on to have very obtuse, non-specific allegations regarding being forced to have sex against her will. Then she talks about certain acts that may or may not have occurred in Panama in 2009, some that may have occurred in 2010. She is across the board, and it's amazing that because of both the severity and temerity of the allegations, that there is no underlying evidence from the state to corroborate this information that we were provided last night at approximately 9:13. In fact, if Ms. Moon was permitted to testify, it would be impossible for us here at the 11th hour to render effective assistance of counsel and ensure that Mr. Paschal receives a fair trial pursuant to the 5th and 14th Amendments to the U.S. and Tennessee Constitution. The allegations took place in a number of cities, spanning a time frame of approximately 15 years. Some of the allegations took place out of the country in Panama. They are not as self-evident and apparent as the uncharged conduct that the Supreme Court addresses in Carrico. So we would respectfully and vehemently urge this court to not allow the state to put in any direct or indirect evidence of this conduct as it relates to an enhancing factor for sentencing.
On the grounds that this does not allege criminal behavior under Enhancement Factor 1?
Yes.
I'm just reading through this, and of course I haven't heard Ms. Moon's testimony, but as I look at this, how are the allegations that are contained in this email not criminal behavior if they are proven by the state? It looks like allegations of domestic violence, holding her in a shower, hitting her with a belt, pulling her by her hair. There's allegations of rape in here. How is that not allegations of criminal behavior?
Well, if the court finds, I would say it's analogous to a 404B hearing where the court would have to find by clear and convincing evidence that the conduct occurred. But, these, if they are used as an enhancement factor for sentencing, obviously this proof is very... we're going to ask for the minimum of the range with Mr. Paschal. The state is asking for a sentence of 16 years. I received, as the court can tell on the top of the email, this statement at 9:59 last night. I want to make sure, was that, because it says AM.
That's where I'm from this morning, where I had to print it off.
Okay. Well, regardless, I received it yesterday evening for the first time. I don't know if it was sent earlier, it was sent after business hours.
Is there authority that requires the state to give you that statement at all prior to sentencing?
Well, we would urge the court under the 6th, 5th, and 14th Amendments, one, to either disallow it or allow Mr. Paschal time to
So you mentioned the 5th, 6th, and 14th Amendment. Let's start with the 5th
substantive and
Amendment.
procedural due process and
How does
effective
the
assistance.
5th Amendment compel the state to give you this statement prior to a hearing. At
Substantive-
trial, you're not allowed to get jinx statements until after the witness testifies. So why in the world would the Fifth Amendment require the state to give this to you prior to a sentencing
Under
hearing?
the Fifth and 14th Amendments, we're saying he would be denied substantive and procedural due process.
In what way?
We have no time to investigate the conduct since we received it last evening at approximately 9:15.
Well, of course, those amendments, as written 200 and something years ago, don't say anything about providing witness statements prior to a sentencing hearing. So certainly, if there was authority that existed that required this sort of pre-hearing disclosure by the state, there must be federal jurisprudence, state jurisprudence, somewhere saying this is what the Fifth Amendment means, or this is what the 14th Amendment means.
Well, I don't think, to quote Justice Potter Stewart, I can't define obscenity or pornography, but I know it when I see it. I know what a fair trial and due process, whether it's procedural or substantive, is. And basically, it's very simple. A due process analysis under the Fifth and 14th Amendment in state and federal jurisprudence basically means that a defendant, a citizen accused, has the right to fundamental fairness. And the fundamental fairness is when you are looking at your liberty and at 9:30 at night you get conduct that spans 15 years, and the only meaningful challenge I can make is to cross-examine someone on this statement, I think he is not given due process. There's a plethora of decisions in a variety of contexts and criminal jurisprudence that there is a requirement for fundamental fairness.
Sure, there's a requirement for fundamental fairness, but again, we've been doing this for over 200 years. I can't imagine if there was authority that compels the state to give this pre-hearing disclosure of a statement of this nature that would actually go above and beyond what the rules of criminal procedure would require at a trial. There would be authority. There would be a decision saying that.
Well, respectfully, if you look at the Carrico case, they acknowledged that criminal behavior had never been defined by Tennessee courts. And you would think that it would. I was shocked. I was surprised. Now, in that case, the uncharged conduct was related to the child abuse that everybody knew about during the course of the trial, apparently, or the investigation. I have no idea about Allison Moon that is talking about domestic difficulties that originated in 2007. So, basically, here's the deal. An enhancing factor, the court has got to rule by a preponderance of the evidence whether they are applicable, not applicable. We have filed mitigating factors in this case. We filed them before. The state, during the course of this prosecution, has been very diligent and has tried to provide information to the defense. I don't know this, but I would assume that they received this kind of at the 11th hour. So basically what we're asking, and I'll boil it down to its simplest components, we've got information that spans 15 years. If we don't have the opportunity to conduct even a modicum of a reasonable investigation and it's used to enhance his sentence for as much as a day, this man will have been denied due process. The answer is simple. Exclude any testimony, any evidence or reference directly or indirectly to the Allison Moore statement or testimony. The record is replete. We have the state filed a notice to seek enhanced punishment, and that's fair. We were able to then look at judgments. We were able to do some independent investigation. But and you ask about authority. If you look at Strickland versus Washington under the standard of whether there is effective assistance of counsel, you don't have to be a rock star, but you have to be reasonably effective. And I'm telling the court I can't effectively cross-examine Ms. Moore without investigating any of these allegations if it's used to confine, enhance my client's sentencing range. It's literally impossible. Okay. I don't know if there was a police report in Panama, in Florida. It says her mother or his mother looked aghast. had no chance to call, investigate, fly my FBI guy down to Florida. So we're not trying to stall, but if the state can do it, enhance a sentence in this manner the night before a sentencing hearing, then the converse of what you're saying, show me some authority to say you can't do it, it's going to open Pandora's box to sentencing records that are replete with issues that, and it's hearsay, innuendo, unproven conduct. Now, if she came in here...
Well, I'm not going to let hearsay in.
Well,
So we can, I'm not going to let hearsay in, I'm not going to let irrelevant evidence in, so we can go ahead and dispense of that.
Right, but if there was a number of orders of protection that we haven't seen, I would say I understand, I would go forward. I can read the OP, I can look at it, whatever. An email that someone purports to have specific recall for a period of 15 years and also would have a bias based on what appears to be an acrimonious history of domestic relations, that's something we would like to explore as well. But we think the answer is easy. One, due process is a fundamental concept that applies specifically to a variety of issues. And I would say the reason there's no authority, no one probably received an email from someone 15 years ago wanting to use that information as a sentencing enhancement factor under Tennessee law. Because it doesn't happen. It never happened to me in 33 years, where you find out at 9:30 at night that there's allegations of conduct that occurred in Panama a decade ago. So we would respectfully ask the court to exclude the evidence or conversely give us a reasonable time to represent 15 years worth of domestic issues that this witness is apparently going to testify about and the state is going to use to seek enhanced punishment.
Thank you, Mr. Isaacs. General?
Judge, first of all, just to set the record straight, I received this email from Ms. Moon yesterday during the day. I've not been holding on to it for a long time or anything like that. I then forwarded it to Mr. Isaacs and Mr. Ammons last night. It was late at night. I've been a little busy preparing for this sentencing, but just to set the record clear, I did receive that email yesterday as well. As far as the testimony itself, the state does believe that this is incredibly relevant to enhancement factor 1, and we believe that it's absolutely admissible as criminal behavior, as the court noted. We believe that if allowed to, Ms. Moon would testify that for years she was the subject of physical abuse by this defendant. The Carrico case is pretty clear that, you can't introduce facts related to the case itself to enhance a sentence. You have to introduce, facts of other instances. The state believes that what Ms. Moon is going to testify to, based on the email that she sent, absolutely qualifies as criminal conduct and is completely appropriate. And as the court noted, I am not aware of any authority that says that I have to provide the defense this written notice or this written statement, but out of courtesy, because we do work well together, I provided it to them last night. I will also note for the court that when we were first set for sentencing back in December, I notified defense counsel that Ms. Moon planned to come and testify, but I did not have these specific allegations from her. So I will just note that they have known she was coming, because that was the issue when we had to continue the last sentencing hearing, was because she had already bought her plane ticket. And so we do believe that this conduct is incredibly relevant to the issue of sentencing. It squarely falls within enhancement factor 1, and there's no authority that says that we have to give them this statement at any certain amount of time before she gets up and testifies. They will have the opportunity to cross-examine her when she's on the stand, and Your Honor will have the opportunity to weigh her credibility and give her testimony whatever weight you feel it deserves. So we would ask that you allow her to testify.
Okay, thank you, General. Well, as I stated, I am unaware of any requirement under the law, procedurally or in decisional law, that A, requires the state to give a witness list at a sentencing hearing to the defense, and I'm certainly unaware of any requirement that the state provide any written statements of an expected witness prior to that hearing. It's not required at a jury trial. At a jury trial, the jinx rule under our rules of criminal procedure simply require the statements to be provided after that witness gives the direct testimony, direct examination. I think the state is well within its rights at the sentencing hearing to put on any proof that is relevant to an enhancement or a mitigating factor. As I stated earlier, I'm not going to allow anything to come in that's irrelevant. I'm not going to allow anything to come in that is hearsay. But I think the state is well within their rights to offer this testimony, assuming it meets those other admissibility requirements. So the objection will be noted for the record. And are there any other preliminary matters that we need to take up at this time? Okay. General, call your first witness.
State will call Kristen Wilson.
All right. Is the rule requested?
Yes.
Okay. If you anticipate testifying here today, if you would please step outside and wait in the lobby. And while you're out there, please don't discuss your expected testimony with anyone. Ma'am, if you'd come forward, please. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, you do.
Thank you. Please have a seat.
You can state your name for the court reporter, please.
Kristen Wilson Chapman.
Now, Ms. Wilson, you are the victim in this case, is that correct?
Yes.
Okay, and we've all sat through the trial now, and so we know the allegations specifically that were brought out at trial, okay? I want to talk to you about some other stuff before we kind of get into that. So how long were you and Mr. Paschal in a relationship?
About a year and a half.
Okay, and prior to the incident that we had the trial for, were there ever any other...
Your Honor, I would object at this point. The state has acknowledged under Carrico that you can't have prior criminal behavior that's related to the same case. Those are the words the state just mentioned a few moments ago. I would object to any conduct that has been uncharged, not subject to a 404B notice, etc. So they can't have it both ways. She said that she knew if it was related to the case under Carrico, it wouldn't come in. Then she gets up and her first witness is attempting to get criminal behavior in under the enhancement factor in the very same case. We would object.
I think what she was offering was conduct unrelated to the issue for which he was convicted.
Well, it's domestic violence related conduct. Just like the court in Carrico said, prior sexual abuse allegations with a 10-year-old. It's not different, it's not separate. There was a confined period of time when these two were together. So we would strongly object, because now under Carrico, criminal behavior, now again, conduct that I'm totally unaware of as it relates to here. It wasn't 404B that was ruled on that didn't come in. It's the same case with the same general type of allegation. Under Carrico, we would object.
General?
Judge, I believe that this is exactly the type of evidence that Carrico allowed into court. The state is prohibited from seeking to enhance a sentence based on facts of the conviction itself. What I was asking Ms. Wilson is about prior instances of domestic abuse, of which she has detailed extensively in her victim impact statement that she sent to the probation office. So the defense has had notice of this. This is exactly what Carrico said qualifies as criminal conduct. It doesn't matter that it is the same victim. These are prior instances. I'm not asking her about the offense for which he was convicted. This is completely separate, and it's completely appropriate under Carrico.
Again, if there is history of prior criminal conduct, that is relevant to enhancement factor number 1. So I'll note the objection for the record and overrule it. I will note that Ms. Chapman is in the unique position here, it sounds like, as being a fact witness, but also being the victim of a crime, who would have a constitutional right under our state constitution to give victim impact testimony as well. So even as it relates to the events that were at issue in trial, she would be able to give victim impact testimony as it relates to those events, and of course provide any other relevant testimony related to any of the other enhancement or mitigating factors. General?
So again, not talking about the instance for what we were on trial on, I want to back up a little bit, okay? Can you tell us about the first time that Mr. Paschel was physically abusive to you?
We had been at a friend's house.
Get you to pull that mic down
Sorry.
just a little bit.
We had been at a friend's house for the day. On the way home, he reached over and grabbed my hand like he wanted to hold it, and he took my pinky finger and bent it all the way back on my hand as far as it would go. We'd had a good day. We hadn't been arguing. I yelled that I was in pain and for him to stop. He laughed it off, said it was funny. Him and his brothers used to do it to each other all the time. Didn't understand why I was upset. Yelled at me, called me a drama queen. And that was the first time that he ever physically hurt me.
Was that the only other time that he ever physically hurt you?
No, there were multiple other times after that.
Can you tell the court about that?
It was in 2019. It was in the fall. We went to like a brew at the zoo type thing. On the way home, he grabbed my hair while he was driving. I was in the passenger seat, and he grabbed a hold of my hair and pulled me over into his lap. Just my head. He pulled me over and was trying to choke me. And the only way I got him to stop was by pretending like I passed out.
Okay, and you said that you think that was the incident that you noted in your addendum, in your victim impact statement. You think that was the incident in September of 2018?
Yes.
Okay.
We ended up, we were going back to my house. When we got back to my house, I jumped out of the car and I ran inside. But I have a keypad lock that he knew the code to. So he came in. I'd locked myself in the bedroom. He kicked the door in. He was physical with me, grabbing me, pushing me around. He broke my TV. He broke several things in my house. Some vases, some mirrors, anything he could get a hold of, he was grabbing and breaking. He kept pushing me back down on the bed. He held me on the bed for some time.
I want to talk about an incident from January of 2019 involving your phone. Do you recall that?
Yes.
Can you tell us what happened in that incident?
We were at his house, and I found out that night that he had been talking to at least 2 other women. We had been dating at that point for a year. He had been talking to other women, so I took his phone and unlocked it and went and hid in the bathroom, and he was sleeping on the couch. And I was taking pictures of the messages on my phone so that I had proof that he had been cheating on me. At some point, he woke up, he came into the bathroom, saw what I was doing, ripped me out of the bathroom, took my phone, took his phone, threw me on the ground, took my phone and put it on the edge of the coffee table and smashed it multiple times and broke it. I was screaming because his sons were upstairs, and so I was trying to get someone to come help me. No one would come help me. I eventually somehow went out the front door. He pushed me over, and he has an electric fence that lines his driveway, and it's got rocks on the other side. He pushed me over that fence. He had my keys. He took them and he threw them out in the woods, so I couldn't get my keys. I had no coat. I was just outside laying on the ground in his yard.
So you said this occurred at his house?
Yes, this was at his house. There's a gate so that you can get out to the road. At some point, I did try to leave, and I told him that I was going to his neighbors to call 911. He told me that they were all his tenants. He owned several properties around his house. He said, no one's going to help you. And so I started just walking up the road.
When you described the first two incidences there, you said that you don't know what provoked it. Is that what you said?
No, neither of those. The first two, I know what provoked the other one. It was because I had his phone and I was taking pictures. But the first two, no, completely unprovoked.
When you were in the vehicle on those times, right?
Mm-hmm.
Okay. And can you recall any other specific instances of abuse during the relationship?
That night that I left his house and I was walking down the road, he eventually, about 20 minutes later, pulled up in his car. He told me to get in the car, and I wouldn't because I didn't know what he was going to keep doing to me. So he pulled around me, pulled into a driveway, and I kept walking past that driveway. And when he backed his car out, he hit me purposely with his car, and then drove back to his house.
During any of these instances, did you ever attempt to contact the police?
I did in another incident, not that one specifically. That night I did end up finding my keys in the woods, and I did to get away, and I slept in my car that night in a random apartment complex somewhere. But the next time, this was right before the incident, so it must have been April
of 2019.
Yes, of 2019. He got mad at me over something, I don't recall what. He held me on the bed for a while, would not let me get up, and then it was yelling at me, but then took his phone and he like smashed it into my mouth to like knock my head back. I still had my phone at that point, and used like the emergency SOS feature. If you hit your power button 5 times, it'll automatically call 911. And I used it and called 911. But once he realized what was happening, he snatched the phone from me. I didn't get to talk to anyone. He immediately hung up when they answered. And they did call back to that number, but he had my phone at that point, so he obviously didn't answer. And
so 911 actually called back.
yes,
to your
and
phone.
they left a voicemail.
Hearsay, Your Honor.
I have the voicemail.
It's not really a factual. I mean, I guess it depends on how she knew that they called. If that was through a hearsay source, it would be inadmissible. But if it was something she personally observed, so if you want to clarify that, General.
How do you know that 911 called your phone back?
They called and they left a voicemail.
Well, I'm not so sure that's hearsay. It's not really a factual declaration being made by another person. I think this witness could testify based upon her own personal observations that 911 had called her back and left a voicemail. We're not getting into the contents of the voicemail or anything like that, just that they had called her back. So I think that is admissible.
And are there any other incidents that you can think of?
Not off the top of my head, no.
Okay.
That's all.
I want to talk to you now about what happened in June of 2019, okay? What we're here for today. We went over your injuries during the trial, but I just want to kind of review that a little bit more. So during the assault, did you lose consciousness?
Yes.
For how long?
About half of it, probably. A few minutes at a time, here and there. I would come back into consciousness and then lose consciousness again.
Okay. Were you in pain?
Yes.
Can you describe that for the court? How the amount of pain that you were in?
A lot of pain. He was hitting my head into the floor. That was the worst of it. Dragging me around by my hair, and the holds that he had on my neck were very painful. I, when it was happening, remember thinking that he was going to kill me.
When you, after the attack stopped and after you'd been to the hospital and everything, did your pain continue for any amount of time afterwards?
Yeah, it got worse. So I think at first I was kind of in a little bit of shock, like when I was talking to the police. But the next day and the day after that, like the pain really set in. My neck, I had neck pain for at least a year after the fact. Every day I would wake up with horrible neck pain that I had not had before that incident. So it got worse for the bit after.
And we all saw the photographs at trial. We saw the injury to your forehead. Mm-hmm. How long was that injury visible like that?
It was, you could see it like black and blue or like yellowing for probably about a month. I had like built up scar tissue here that I could feel for several months after the fact.
And can you tell us, when you went to the hospital, what were you diagnosed with?
A concussion.
Your Honor.
Can you tell the court now how this whole thing has affected you?
I have a lot of anxiety and a lot of fear. Even with him in jail, it's hard. Every car that drives by a little bit too slowly. I'm looking out the front window. I fenced in my yard because I do not feel safe walking my dogs even around the neighborhood anymore if my husband's not with me. When I open the door to let the dogs out, I scan the whole perimeter of my yard because I'm just scared.
Is there anything else that you want to tell the court about how this has affected you or anything else?
Not that I can think of off the top of my head, no.
I'll pass the witness, Judge.
Thank you, Jennifer. Cross-examination.
Good afternoon, Ms. Wilson.
Good afternoon.
You've talked about a number of instances of alleged abuse that occurred aside from the facts that were in the trial, the June 19th incident. If we could take those sequentially, you indicated to Ms. Good that there was an occasion where he had bent your finger back at a friend's house, correct?
It was on the way home from a friend's house, yes.
Okay, can you tell me the year that happened?
2018.
Can you tell me the day of the week and the month that happened?
I know it was in April because it was around Easter, but I don't know the day of the...
Okay.
Oh, it was on a Sunday. I'm sorry. It was on a Sunday. I do know that.
And it's true, is it not, that based on that incident of, quote, bending your finger back, you did not terminate your relationship with Mr. Paschel, correct?
We didn't speak for about 2 weeks, but we did end up getting back together.
So the answer is yes, you did not terminate your relationship with Mr. Paschel, correct?
Ultimately correct.
You did not seek an order of protection from the Knox County Circuit Court, correct?
Correct.
You did not call 911, correct?
Correct.
Now, in September, you described an incident that was more involved, correct?
Yes.
Do you recall at what time, day of the week in September, those alleged events would have occurred?
It occurred at night, but that's all in September.
And is it your testimony that the allegations of striking, slapping, choking occurred in a motor vehicle?
Some of them in the motor vehicle and then some of them back at the house.
Okay. And whose motor vehicle were you in, Ms. Wilson?
Mr. Paschal's. And he was driving.
And at that time, Mr. Paschal was driving the motor vehicle, correct?
Yes.
And it's your testimony today here under oath that Mr. Paschal struck, choked you to the point that you lost consciousness as he was operating a vehicle on a public street or thoroughfare?
We were at a stoplight on Kingston Pike, and he was driving with one hand and he grabbed my hair with the other.
So the light had momentarily turned red. You're in a public street, obviously with a light traffic control device. That means there was traffic that flowed 4 different ways, correct?
Correct.
And you're saying that with one hand he's operating the car and the other hand he's able to strike, strangle, choke, grab you by the hair?
He grabbed me by the hair and pulled me over into his lap and then held me there until I pretended to go unconscious. I didn't actually go unconscious.
Okay, so he's operating the car and you're saying he's choking you to the point of almost unconsciousness at this intersection?
Yes, at the stoplight. The car was stopped.
Yeah. And of course, you have pictures of the marks, I would assume?
I did not take them, no.
And as an educated professional young lady, I'm assuming if the abuse was that severe, you reported it to law enforcement?
I did not.
I would assume that you contemplated seeking an order of protection where there would be specific findings and a court could make a decision on whether you were abused and set parameters of contact. Did you do that?
I did not file an order of protection.
Did you know what an order of protection was at that time?
No.
You didn't?
Not at that time, no. I'd never been in an abusive relationship before.
And you're a school teacher and you have a college degree and you're telling this court that you didn't know what an order of protection was from somebody that had been the victim of domestic violence.
Not
Judge,
of domestic
I think
violence.
she just testified that she previously had not been the victim of domestic violence. Just clarification.
Well, this is 2018, so I guess the finger incident, you didn't consider yourself a victim of domestic violence?
I don't know. I don't know what I was
testimony
thinking.
was she had never been in an abusive relationship prior to that, is how I understood the testimony.
And the night where you indicate that Geoffrey Paschel was operating the vehicle and able to subdue, strike, and strangle you to the point that you malingered unconsciousness, Mr. Paschel had been drinking, correct?
Yes,
You'd been drinking, correct?
yes,
And it seems like that is a common denominator as it relates to the allegations of abuse, correct?
sometimes.
And the issue with the bent finger, it's true that you both had been drinking, correct?
I don't recall that day.
So you do not have a clear recollection of whether you had or had not consumed alcoholic beverages when you say that incident occurred?
I don't recall that day of the bending finger. I don't remember.
All right, let's go to the next allegation that you've testified about this morning. On June 7th, that Mr. Paschel took your iPhone and damaged the phone, correct?
Yes,
And based on that, let's go back to the September 2018 conduct. After that alleged event, you did not terminate your relationship with Mr. Paschel, correct?
I did not.
January 7th, you say that he grabbed your iPhone, threw the phone, damaged the phone, correct?
He broke it over a table.
And at that point, once again, you did not call the police, correct?
I did not know.
You did not terminate the relationship with Mr. Paschel, correct?
I did not.
You did not go to the Knox County Circuit Court downstairs and seek an order of protection, correct?
No, I did not.
You did not seek a warrant for vandalism and damage to your phone, correct?
Correct.
And do you recall, Ms. Wilson, giving a statement to Tennessee Department of Correction, Knoxville Office of Probation?
Yes. My victim impact statement?
Yes.
Yes.
And it's true, is it not, that even though you indicated that there had been other instances of abuse, you never detailed any of the information in the report that you're testifying about here today, correct?
I'm not sure what you're asking.
Well, you never talked about bending the finger, you never talked about,
Okay.
none of those facts appeared in your victim impact statement, correct?
I'm not sure. I don't remember.
May I approach?
Yes.
Ms. Wilson, let me ask you if you can review paragraph 17, and it also continues on the back of the report, and tell me whether that refreshes your recollection.
The only thing that I mentioned in here that we just talked about was taking my phone and car keys, so I couldn't get away.
And you testified, Ms. Wilson, about the injuries that you say you sustained on June 19th that were the subject of this trial, correct?
June 9th, yes.
And you would agree that those injuries were, the objective evidence of the injuries was limited to the pump knot and the bruising and hematomas, correct?
From the pictures from the trial, is that what you're asking?
Yes.
Are those the extent of my injuries?
Yes.
The pictures from the trial were the extent of my injuries from the June 9th incident. Yes.
And Ms. Wilson, you are a intelligent young woman that obtained her college degree, correct?
Yes.
You're currently a school teacher, correct?
Yes.
And based on all of the information that you have talked about this morning, there was nothing that rose to the level of you severing your relationship with Mr. Paschal prior to the allegations that were subject to this trial, correct?
I mean, we broke up several times throughout this, 2 weeks, 2 months at a time, over the course of a year and a half, based on these different
Well, my question
events.
was, you never terminated your relationship
But we did
with Mr.
eventually get back together, yes.
And you would agree with me that there is one common denominator regarding these allegations, aside from both yourself and Mr. Paschal being present. Well, there are two common denominators. One, aside from June 19th, there were no police reports, pictures, documentation, etc., correct?
There were pictures, and he deleted them from my phone.
There was no calls to 911, correct?
There was a call to 911.
And those, you don't have copies of those calls?
I have a copy of the voicemail that they left on my phone.
Do you have any other indicia of evidence of what you're talking about today?
No.
No orders of protection, correct?
Yeah, other than the one from June 9th.
Nothing further.
Thank you, Mr. Isaacs. General, when you redirect.
Very briefly. Ms. Wilson, why did you stay with Mr. Paschal for so long, even after the first incident of abuse?
He's very charming, and he's very persuasive. At first, the first couple of times it happened, it was crying, begging, please take me back. I am so sorry. I don't know why I did this. I want to marry you. I want to be with you. The later incidents that happened were threats. He told me, you will have nothing by the time I'm done with you. Your family, your friends, everything will be gone. And I was so brainwashed and so broken at that point that I just completely believed him. I did not believe that I was worthy of anything else other than what he was doing to me.
Did you love him?
Yeah, I did.
Nothing further, Judge.
You recross.
No, Your Honor.
Ma'am, thank you.
Thank
Please
you.
step down. Sure.
Your Honor, in terms of Exhibit 1 marked for ID, does the court still have that?
Yes, I do.
Okay, just in case we...
No, thank you. I'll make sure this gets back to the court. Ma'am, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please have a seat.
Can you state your name for the court reporter?
Allison Moon.
Ms. Moon, do you know Geoffrey Paschal?
Yes, I do.
And how do you know him?
I know him because I was previously married to him.
Okay. When were the two of you married? What were the years?
We were married I met Mr. Paschal in 2006, late 2006, and shortly after that we got married, and we were married until mid-2013, roughly.
So about 6 years you were married. Okay. Do the two of you have any children together?
Yes,
And how many?
we had one.
Okay. And how old is it boy, girl?
It's a boy. His name is Crusoe, and he is 10.
All right. And you know why you've been called to court today.
Absolutely.
And you know that Mr. Paschal has been convicted of several things related to Ms. Wilson, correct?
Yes.
I want to talk to you specifically about some things that happened during your marriage to Mr. Paschal. At any point during your marriage, was there physical abuse?
Yes, there was.
And if you could, to the extent that you can just kind of recall it off the top of your head there, can you just tell us about specific instances that you remember?
Sure. Early into our marriage, a couple months in, there was definitely verbal and emotional abuse.
Your Honor, I would object. The enhancement factors talks about prior criminal offenses or criminal behavior. Verbal domestic arguments would not rise to the level of satisfying the enhancement prong under Tennessee law and would not be admissible or appropriate. So we would object, move to strike, and ask that it be excluded further from this hearing.
General.
Judge, I will just ask her about the physical abuse. However, if there were instances of verbal abuse where you felt like you were
Object to her talking to the witness. If she can ask the question and allow me to object.
Okay, here's how I'm going to rule. I'm going to sustain the objection in part with a clarification. We don't need to hear about verbal altercations. The general is aware of our state's assault statute and how certain verbal behavior could rise to the level of criminal activity. You guys are well aware of that. I will allow that type of evidence, but otherwise, the general could just remain focused on questioning regarding specific instances of alleged criminal conduct.
Yes, Judge. And so with that, can you tell us about any physical abuse or were you ever put in fear by any verbal abuse?
Absolutely. There were many threats made to me and to my family. He was violent to me on numerous occasions.
And I'm going to stop you for just a second. When you say threats, what kind of threats?
To kill me, to harm my family, and one of the last physical altercations that we had was I was arriving home after spending time with my cousin, with my son at the time, and he didn't believe that I was where I said I was, and showed up at my home, grabbed me and threw me into the bathroom, closed the door, told me not to leave, or there would be consequences. He took Crusoe and put him in the car and left. He had taken my keys along with that. After sitting there for a little while, I opened the door and quietly came out. He wasn't in my house anymore. Happened to find, I found my phone and contacted him to make sure my son was okay. That was my primary concern. Shortly after, he came back to my house, and nowhere in sight was my son, but he immediately attacked me and grabbed me and shoved me into the wall, threw me on the ground, strangled me. When I finally broke free, he went and swung at me, and I moved so he could hit the top of my head versus my face. And after that struggle went on for a good 20 minutes, I finally was able to plead for him to stop. I asked where Crusoe was. He went and got him out of the car. He had been in the car by himself the whole time.
How old was he at this point?
He was a year and a half. And he hung around and knew I was mentioned that Crusoe had to be put down for a nap, so he hung around for that. After that, he pulled me into our bedroom and started taking off my clothes. Was wanting me to have sex with him. I was scared that if I resisted, that he was going to become violent again. So I just let it happen.
Objection, that's not criminal behavior.
I'll be the one who determines what criminal behavior is
That's why
here. I think that's relevant. She's describing these attacks. We can't pigeonhole her testimony into the very small confines in which you're wanting to do this. If we were trying this case at trial, for instance, this would all be relevant to show the circumstances surrounding this alleged conduct. So the objection has been noted. We need to hear what this witness has to say. General?
Were you done with that, sir?
No, so when he was forcing me to have sex with him, I was in pain. My back was hurting. It was just when he was grabbing me in the course of it, it was very, very painful. And then it was over and he left. And then shortly after that, I had a friend come over and help me pack up my things in one day, and then I took my son and myself and we moved to Florida to live with my parents, and that was the last of the violence.
I want to talk to you. You were in the courtroom when we were talking about the email that you sent to me yesterday.
Yes.
I want to talk to you about some specific incidents that you listed in here.
Object to leading. I mean, she can ask her. I think she just testified that was the end of the abuse. And so now if she reads from the email one that's leading, and I think it would be appropriate to use that. I mean, she's seeking to, I guess, introduce a prior consistent statement.
As I took Ms. Moon's testimony, that was the last incident in time before she left Mr. Paschal. So if what I think is happening is that the prosecutor is referring her to incidents that occurred before that. So, of course, the state can't lead. I don't think she was leading. I think she was just directing her to other incidents. So I'll note the objection, General. You may ask.
Can you tell us about the first time that there was physical abuse?
Yes, 4 months after we were married, we were having a conversation, and it was not long into our marriage, I began to question his fidelity and whether he was maintaining loyalty and being honest with me about things. And so when I brought it to his attention, he would often get defensive and start to make me think that what I was saying was wrong, or that I was crazy for thinking so. And the first time I had said something, and it just immediately snapped, like no warning. He jumped on me and held me to the ground, but had his hand over my mouth, just squeezing it, like, hey, stop talking, basically. And after that first time, he was extremely apologetic and promised it would never happen again, and wanted this marriage to work out. And I believed him. After that, though, there were many instances of increasingly more violent things that he did to me, such as strangling me, holding me on the ground and strangling me, and dragging me by my hair, backhanding me in the face. He's elbowed me in the back, and each time he would be threatening me and I didn't believe I could do anything about it, because oftentimes my phone would have ended up broken in the course of our arguments. My keys would go missing, or he would have him, and then he's often disabled my car before, so I couldn't leave even if I had the means to leave or get help. Where he lives in a rural area, it would take me a long time to get out of the house and run to a neighbor, so I felt very isolated. Slowly, from the beginning of our relationship, I became estranged from friends, and it became more and more of a fight to see my family. Financially, I didn't have the means to go and get away from him. He made me dependent on him. But yeah, it went on for a long time.
Did you ever call the police during any of these instances?
I did one time.
Okay, can you tell us about that?
So there was a time in our marriage where we were separated. I lived in Florida to go and get my master's, and he showed up unannounced one night, and this was during a period where things weren't going well in our relationship, since it was a roller coaster throughout our whole marriage. He showed up unannounced and walked in through my back door at my parents' house, and I was startled because I wasn't expecting him. So the first thing I did was hid my phone, because the typical pattern is he'd take my phone so I wouldn't have means to contact anybody. And when I came back, I found him in the kitchen, and he got close to me and was talking to me and trying to smooth talk me. And then before I knew it, I had been like backed into my bedroom, and I remember him forcing me onto my bed, and he started touching my private areas and telling me we're gonna have sex, and I didn't want it. I was telling him no, and I was able to wiggle free. I ran out of the back of my house, knocked on my neighbor's door, rang the doorbell several times, and he had come out of my house and left, and I went inside and locked all the doors and called 911.
And so you actually did make a police report at that time?
Absolutely, yes.
And you described all of these events?
I did make a police report, but I didn't follow through with charges because I was so afraid of what he would do if he would come back and do worse, or he was unpredictable.
You said that was Florida?
In 2010, yes.
Do you know where Mr. Paschel resided at that time?
Tennessee.
Okay.
And you said that this sort of abuse was kind of happening throughout your entire 6-year marriage?
Yeah, it came in cycles. We would be okay, and things would seem normal, and then with little notice, he would snap, be in like a fit of rage. There were always arguments about, if he was telling me the truth. I was always very weary, but everything would always be unpredictable to what would happen next. And I would leave. I've left numerous times, but he had an extra key to my car and would come and take my personal belongings out or disable it so I couldn't go anywhere. So unless I relented to what his demands were or what he wanted, which was usually for me to come back and promising me things were going to be okay. And then a few months later, the cycle would begin again, and there would be an argument that would lead to him being violent, and I'd be right back wishing I had left or could leave, but always felt like I couldn't.
Judge, I'll pass the witness.
Thank you. Cross-examination.
Good afternoon, Ms. Moon. My name is Gregory Isaacs. I represent Geoffrey Paschel. You and Ms. Wilson are friends, correct?
Yes.
You talk almost on a daily basis, correct?
More of a weekly basis.
And in fact, you have an ongoing domestic civil case against Mr. Paschel, correct?
I do not have I have a domestic case. Yes, it's child custody related.
Yeah, you hesitated. There is a pending civil litigation where you are the petitioner, he is the respondent, correct?
It's actually been resolved. That's my understanding. Now, there might be a new motion for something else, but...
Okay. And in fact, Ms. Wilson, in that case, testified on your behalf, correct?
Yes.
And you and Ms. Wilson have talked about your testimony here this morning, correct?
No, not my testimony this morning.
Well, you've talked about your testimony, correct?
We've shared experiences together, but that didn't begin until after 2019.
Okay.
And
if you could please answer my question.
Judge, I would ask Mr. Isaacs to stop kind of being a little hostile towards this witness. She is, in fact, answering your question, and you're getting a little hostile with her.
We're fine here. Just let Ms. Moon give her answer, and you can ask your next question.
Well, Ms. Moon, I apologize if my demeanor is hostile, but Your Honor, you're a hostile witness. You're adverse to Ms. Paschel, and you never talked about in direct any of this information regarding your relationship
The
with
record,
Ms. Wilson.
let me clarify something here. Ms. Moon, as far as I can see, is not being a hostile witness. That's a legal term of art.
It is a legal term.
She is answering both parties' questions, I feel, to the best of her abilities. The court is not finding her to be a hostile witness. I just want that to be clear in the record. Go ahead, Mr. Isaacs.
When did you last speak with Ms. Wilson about your testimony here this afternoon?
the last time we spoke about it had been within the coming weeks of being here.
Okay. And in fact, you wanted to testify so much that you actually have come here from out of state, correct?
Yes.
And Ms. Wilson asked you to come here, correct?
There was no question of her asking me to come here. I was going to be here to support her.
Yeah. Well, let me ask you this. Can you relate to me the substance of your conversation with Ms. Wilson about what your testimony was going to be this morning?
We discussed that we were going to be sharing our experiences that we endured while with Mr. Paschal. That was it, though not in detail because there was no need to at that point.
Well, why would you feel the need to talk to Ms. Wilson about testifying on behalf of the state truthfully regarding these allegations that span over 15 years? I mean, they're 15 years ago with the 6 years you were married. Because
we were friendly and we're friends and we've endured similar experiences, and it's through a means of support to one another to know that she's not alone.
Mm-hmm. And would you agree with me that both you and, well, let's not talk about Ms. Wilson, that you don't like Mr. Paschal, your ex-husband, the father of your 10-year-old Caruso, correct?
I don't have any feeling. I'm indifferent to him. He means nothing to me either way. I don't spend a lot of time thinking about him.
So if I recalled Ms. Wilson to the stand, she would say that you've never had disparaging conversations about Mr. Paschal?
We both agreed that he was a very harmful man.
So my point is, you both have a bias against Mr. Paschal, correct?
Yes, we definitely do. I believe our experiences warrant it.
And you have not only a bias, but a very strong bias, correct, Ms. Moon?
I endured several instances of violence with this man. Of course, I have feelings of dislike toward him, but I don't dwell on it, or most of the time our conversations over the couple of years we've talked to each other have been about our lives.
And let's talk about these allegations. Now, you are you employed?
Yes.
What's your position? Are you currently employed?
I'm a teacher. I'm a fourth grade teacher.
Okay, you're a teacher. Obviously, you have a college degree, correct?
Yes.
And you know that there are resources to help people if they are, in fact, involved in an issue of domestic violence, correct?
Absolutely.
And when many of these allegations allegedly happened, you were residing in Florida and Mr. Paschal was residing in Tennessee, correct?
For half of our relationship, we were, well, for 1 year of our relationship, we lived separately, or year to 2 years. The first 3 years of our marriage, we were living together, and many of the altercations happened during those 3 years. And they got increasingly violent over those 3 years. When I came back and after I had my son, that's when I experienced the most violence from him.
All right, let's get this straight. One, for the 3-year period, no calls to 911, correct?
No calls to 911.
So we can't tell if you ever made a complaint of domestic abuse or if there was an escalation of domestic abuse, correct, as it relates to 911 calls?
Correct.
There were no criminal warrants taken out regarding this conduct, which appears to constitute assault, battery, strangulation, false imprisonment. No warrants. Never
Great.
sought to have Mr. Paschal arrested, correct?
No, I was in complete fear of doing so with the threats he had been making to me leading up to these physical violent altercations.
Never once sought an order of protection,
For what? He could still come after me. He had a copy of my key.
question
So
is,
no, I didn't believe I had the means to do so and be safe from this individual.
All right, so for the first 3 years, you say there was abuse, and instead of running, instead of calling 911 or getting an order of protection, you had a child, correct?
And I didn't have the means to call 911. I didn't have the means to leave the house. He had my keys. He would destroy my belongings.
Or if you could answer my
So
question.
no, I didn't.
Okay,
Did we have a child to make our relationship better? I mean, there's no telling. Did I think it would help? Perhaps, but honestly, because he would describe to me that that would make a difference.
Well, my question to you is, after 3 years of this alleged abuse, instead of asking for help, you decide to start a family with Geoffrey Paschel, correct?
Yes.
And you started a family with Geoffrey Paschel because you think, or you thought, he would be an appropriate father, correct?
I was hoping he would be an appropriate father.
So, really, Ms. Moon, if you thought he just continually abused, slapped, strangled, drug you around, that's not someone you would have planned a family and have children with, if that's true, correct?
After being several years outside of our marriage, no. Back then, my head was not clear. I was filled with the threats and the fear that he built, the criticisms, the constant harassment. He did nothing to make me believe that otherwise.
And this abuse and this brainwashing was so severe that you never called 911, you never called the police, and you never got an order of protection, but yet you started a family with Geoffrey.
Yes, I did, though I didn't have the means often to get the help I needed when I needed it, because
Okay.
after the storm, it was calm, and I thought I could believe that things would improve, and they never did, and it was a vicious cycle that.
Okay. Now, you were married to Mr. Paschel from 2006 to 2013.
Yes.
And there has been a variety of very acrimonious civil lawsuits, pleadings, motions, contempts, etc., correct? Filed in court.
Between who?
Between you and Mr. Paschel.
Yes, regarding child custody.
And it was and is a hotly contested issue in circuit court, correct?
It was concerning based on his continued criminal behavior and repeated actions that kept happening with other women. So yes.
Well, let's talk about what happens today. The longer the sentence that Geoffrey gets, that helps you with your custody battle with 10-year-old Caruso, correct?
Caruso already did not have a relationship with his father for the last 5 years, so it wouldn't make a difference to me today.
Well, you filed a petition to terminate Geoffrey's parental rights, correct?
Correct.
So you have other motivation than the abuse that you never told anybody about to testify adversely to Geoff Paschel today, correct?
I have motivations to do what I think is right by myself, by my family, by the women that he will continue to be a predator to.
The women. So you represent the women, that's why you're here?
No, I'm saying theoretically, I'm not one. Clearly I'm one of two, and there's other women that he's been involved with that have endured violence by him.
How do you know that?
Because I've seen court documents that state that from other people he's married to.
Mm-hmm. And you all talk, correct?
Incorrect. I've
Talk to
never
Ms.
had a
talk to Ms.
conversation
Wilson.
with his most recent wife.
Well, let's talk about this period that you were married from 2006 to 2013. Mm-hmm. Okay? You have talked about issues of abuse that happened in Tennessee and then issues of abuse that happened in Florida, correct?
Yes.
Can you name a single date and time that one of these alleged events occurred other than the nebulous 6-year period. A single date or time if these are indelibly etched in your memory that they occurred.
I mean, I can remember months. Dates are a little bit more challenging to pull, but I know that, when he showed up at my house, I believe it was August 28th or 29th of 2010. I know the last violent act that I recounted was August 2013. It was within the first weeks of August. But remembering, I don't know how remembering a specific date is important. It's been a long time. And clearly these memories stick with me, but I don't remember the specific dates of many of the encounters.
Well, let me ask you this. If this abuse was so severe and so pervasive, you can't even tell the court the day of the week or the date that it happened?
Again, with time, it leads my memory to be fuzzy on specific dates and times. I often, in the midst of being abused, I'm not going to refer to a clock so I can remember in the future to tell the court what time something occurred. It just doesn't.
No medical records provided to the prosecution of abuse?
No.
Absolutely nothing to corroborate your story, correct?
Correct.
Just you and Miss Wilson talking on the phone week after week, and you representing all those women to light Geoffrey up in criminal court, correct?
I have said in court documents prior to meeting Kristen, my experiences with Mr. Paschal. So this is not new, as in me talking to her and coming up with a story.
Hey, let me ask you this. The state has represented that you sent them this email yesterday, correct?
Yes.
You knew the hearing was today, correct?
Yes.
And so you chose to give them all this information of abuse, knowing that my investigators in my office couldn't investigate it, correct?
Judge, I can interject here. I specifically asked her to send me this yesterday, and that's what she did.
Then I will withdraw the question. I have nothing further.
Very briefly, Judge. How did you and Ms. Wilson begin communicating with one another?
I received her police report in the mail from my lawyer.
Okay, and
on August of 2019.
Did it contain her phone number?
Yes.
Did you reach out to her first?
Yes.
And was this before or after the June 9th of 2019 incident?
After.
Okay. And prior to coming into court today, did you and Ms. Wilson get together and say that you're going to testify one way and she's going to testify one way? Did that ever happen?
Definitely not in that way, no.
Okay. And like you stated, the allegations that you're talking about, this is not the first time that you've been in court and stated these allegations.
Correct.
You pled them actually in many of your custody documents.
Yes.
Okay. Custody documents that Mr. Paschal received.
Yes.
Okay. Nothing further, Judge.
Briefly. And in fact, Ms. Moon, you really were not as scared and frightened of Geoffrey as you're saying today, correct?
Absolutely.
Well, you were so not frightened and so comfortable that in 2013 you agreed to give him 50-50 custody with your son Caruso.
Yes, I agreed to 50-50 custody up until the age of pre-K, where he would begin school. So in my mind, if I could come to an agreement with Mr. Paschal without there being threats and further violence, then I was going to try to be amicable and do that.
So you have somebody that you describe and you're still describing as violent, unpredictable, and whatever, and you agreed to let him have Caruso 50% of the time, unsupervised, no parameters, correct?
Correct, and I was doing that in hopes that he wouldn't do something to hurt my child or for my child not to witness further domestic violence with other women he brought into the home. And
Well, let's not talk about other women. We talked about that before, but isn't it true that you or any mother, if all of this violence was true, would never hand their child?
Object. He's asking
Well,
her to speculate what
so-
other mothers would do.
What?
Sustained, you can rephrase the question.
I don't think I have anything else to ask this witness. Thank you, Ms. Moon.
General,
Nothing further.
Ms. Moon, thank you for being here today. Ms. Moon, subject to recall. Okay. You can remain in the courtroom if you'd like, Ms. Moon.
Can we approach?
Yes. Before the state calls the next witness, we do need to take about a 5-minute recess. If you anticipate being a witness in this case, as we've discussed, do not discuss your anticipated testimony with anybody until you're called into the courtroom and sworn. We'll be in a 5-minute recess. Thank you all. You can be seated. All right. Okay.
Judge, unfortunately, something literally just happened to this laptop and now it will not do anything. Is there any way could you watch it on your computer? I have to.
Yes. Yeah, I think I can
I
do
mean, we
that.
don't necessarily need to play it, you know.
Okay. Well, if it's being entered, I'll need to see it, so.
Right. I mean, play it like.
This with counsel, the state's attorney is here with us. I was informed by my court officer during the break that we were having an issue with one or more people in the gallery, I'm not exactly sure, having verbal, audible responses to some of the testimony that was being provided. I want to make very clear that we have to maintain decorum and order within the courtroom, and part of that is that there can be absolutely no responses from the gallery, either verbal or nonverbal, as to any of the testimony that has been provided. I understand my court officer during the break provided the appropriate admonishment to that effect. And I also understand that Mr. Isaacs spoke to some of the people on his side of the aisle to that same effect, and I do appreciate you for doing that, Mr. Isaacs. General, you ready to proceed with your next witness?
I am this.
All right.
And done calling live witnesses at this point. We do have a video jail visit of the defendants that we would seek to introduce. As I guess we haven't introduced anything yet, have we? We had the one for ID, but
Yes, this will be number 2.
Okay.
Is there any objection?
None.
Okay, this will be received as number 2.
It's about a 15-minute long video of that the defendant has a jail visit with his mother, I believe. If the relevant portion that I was wanting to play for the court begins at 7 minutes and 45 seconds.
Okay, would you like to publish that at this time?
I would, Judge.
You said 7 minutes and how much?
45.
Gonna get it, I'm gonna talk to her and said that we can. What are you eating? And for me to go to your house and make sure everything's okay?
No, I just got it under control. Keep it still.
Josh,
For the record, I've started the video at 7 minutes and 30 seconds.
Ashley,
Go to what?
Josh and Ashley are there, but they need to leave, right?
Where are you at?
They already left.
Oh. That's the other. If Lily can talk, if Lily does talk to her, maybe she can say, like, you know, think about it to the children, how they're affected, or something like that, you know?
Okay, who does she want us to tell it to? That person?
Yeah, that person.
Okay, I'll tell him. I think she was gonna do that anyway.
Yeah, she probably should make a visit, though, not an unsolicited visit, not a call, not an email.
Okay, tell her to just go there and talk to her.
With the children or something.
With the children, okay, I'll tell her. I'll call her now.
Yeah, maybe Miles can talk, you know, and say how devastated he is or whatever.
Yeah.
Yeah.
If she could help if she would do that now, right?
Well, she could talk at the sentencing and say, I don't, you know, I think he's, whatever, learned his lesson. But,
You want her to do that now, or you want her to wait a bit?
that's up to her.
Okay, I'll tell her. She said she had a plan, so I'll talk to her and tell her you need to make a visit, because I sent her the phone number, but I don't think it's probably the same number, is it?
It's not, no.
No, I didn't think so. That's what
You
I
know
said.
Brittany's phone number?
Huh?
You know Brittany's phone number?
No, I don't have Brittany's phone number.
Um,
No, I don't think I do. I mean, I might.
it's 416 something, something, something.
416 something, something, I'll look. 416 something, something, okay.
Um,
6, okay. All right.
745, 738 or something.
745
7038 maybe?
7038. I'll look and see if I have it. I don't think I got rid of any of those phone numbers, so. Do you think you want her to contact her too?
No. I mean, Mary can try to, or anybody can try to keep Taven in the mix, you know?
I know. Oh my God.
To keep talking to him and
Okay.
know he has his family.
Okay. I know. Oh my God.
But Lori doesn't need to call that girl. She would need to make a visit.
I'll tell her. Visit to that girl. Okay.
An unsolicited visit, like you said.
Unsolicited. Okay. Unsolicited. Okay. I'll tell her.
Either to her house or to the school or whatever.
Okay. Does she know where the house is? So the kids do, right? Paxton to Dakota.
Yeah, 1325.
Say it again.
1325.
1525.
1425.
Okay.
Aldenwood.
What was that?
Aldenwood.
Spell it.
ALDEN Wood.
Okay, got it. Is that a drive?
doesn't matter.
Okay,
Judge, we can stop it there.
1425.
Okay, for the record, I'm stopping the video at 10 minutes and 41 seconds. General, I'm assuming the date on this is, it was recorded on January the 28th of this year?
It was not, Judge. This was actually October the 17th.
Okay. All right.
So,
Okay. Any further proof, General?
yes, Judge. The next thing I would ask is I've got certified copies of convictions from Blount County, as well as certified copies of convictions from the district court in the Eastern District of Texas. So I would ask those to be the next exhibits. The Texas ones are two separate ones. So we want to make those separate, or
Sure. Let's mark them all separately. Any objection to those, Mr. Isaacs?
The only, obviously I will take the state's representation that they are certified. Pursuant to TCA 4035-106A1B5, there needs to be a finding beyond a reasonable doubt that the out-of-state conviction, if it's used to determine a sentencing range, must be compared to Tennessee law as it existed at the time. I understand from talking to Ms. Good, she is going to establish that prong, but that would be our only objection as to the foundation on the federal conviction from out of state.
Okay, sure. So it sounds like there's no objection as to the admissibility, but you guys may argue over the effect of the...
Well, it's not admissible unless she can show what the sentencing range is that existed at the time beyond a reasonable doubt. Under Tennessee law pursuant to State v. Brooks.
Well,
I guess it's admissible.
It'd be admissible,
to argue
sure.
It can be used to
Right.
make him a range two.
if for no other reason, it would be admissible as prior criminal conduct. But we can argue as to the import that it has on what range he's sentenced at today, for sure.
So, in response to the court's question, we don't object to admissibility. We would like to be heard on the issue of whether it should be considered an enhancing factor for range two.
Of course. Yes, sir.
next thing would be the pre-sentence investigation report and the addendum to the pre-sentence investigation report. Do we want those as a collective or?
Any objection to those?
None.
Collective's fine, I think. They're really the same document.
Let's see here. Judge, I would also like to enter a copy of the Ms. Wilson's medical records along with the affidavit of the custodian of records at this time.
We would make the same objection regarding the medical records that we did at trial under the 90-day notice provision, and we've still not received, other than the memorandum, any of the statutory prerequisites to have medical records admitted.
Judge, I'm not sure what this 90-day issue, I'm not sure that the rule actually calls for 90 days.
So we're talking about authentication through the affidavit of the custodian of records.
Yes.
And I know there's a notice provision. I don't know. Well, for one, has there been notice provided that you intended to introduce these through an affidavit?
So I provided them with these records almost 2 years ago. At trial, the court did exclude the medical records because I had not filed written notice. However, and if the court would like to see the case, now I can't remember it, of course, because we're talking about it, there actually is case law stating that if the records are provided to defense counsel in discovery, then that in and of itself puts them on notice that this evidence could be, sought to be introduced, and that written notice actually is not required by the rule.
Can we see that case?
We try, and give me a moment, I'm happy to go find it. But again, they are on notice that we could seek to introduce these, even from the trial.
Well, we are on notice, and the operative term is seek to introduce, so we would renew our same objection we made at trial.
It does say that written notice is required. However, the case that I'm specifically referring to, and I'd be happy to go and pull it if need be, states that once the state actually puts it gives it to defense counsel and puts it in their discovery response or something like that, it then puts them on notice that it could be sought to be introduced.
Okay, well, I'm in a position where I don't have that case in front of me. All I have is the rule, and the rule is pretty clear that a party intending to offer a record into evidence under this paragraph, referring to the business records, basically, must provide written notice of that intention to all adverse parties and must make the record and declaration available for inspection sufficiently in advance of their offer into evidence to provide an adverse party with a fair opportunity to challenge them. So I'm kind of at, here's what the rule's telling me. I don't have any authority telling me otherwise that I'm aware of. So I will sustain the objection at this point. That'll be the court's ruling.
That's fine.
All right. Any other proof, General?
And Judge, I don't know. I do have a copy of the statute as it existed in 2000 related to drug offenses in Tennessee that Mr. Isaacs was referencing. I don't know if we want to introduce that as an exhibit or just for
problems
time.
that for the record, I'm fine
Okay.
on the federal conviction.
Okay.
Now, is that a federal statute or a Tennessee
This
statute?
is the Tennessee statute. So and I guess we can talk about this a little bit. So the conviction, the federal conviction is for possession of cocaine with the intent to resell.
Attempted.
Well, he's got an attempted and there's two. And so I've got the Tennessee statute as it existed in 2000 at the time of those convictions related to the possession with the intent to sell
I see.
controlled
Okay.
substances.
All right. Thank you.
So, do you want to like to see that?
Yeah, Mr. Isaacs, you mind if I take a copy of that?
Yeah.
Okay, thank you.
So I think that is all of the proof at this time. Just ask for argument.
Okay, the state has rested its proof at sentencing. Will there be any proof in the defense?
Your Honor, we have a number of arguments to make regarding our sentencing memorandum, but we have no proof at this time.
Okay, very well. Let's move on to argument. And I guess if both parties could begin with their arguments as to the appropriate range of sentencing.
Judge, it is the state's contention that Mr. Paschal is a range 2 multiple offender based on numerous convictions that are now entered into the record, the first of which being a conviction, actually 2 convictions out of Blount County, but the state does concede that for purposes of enhancing the range, because the date of offenses were the same, I think that they would actually only count as 1 conviction. But those were for a B felony, the sale of, I believe, and if I may draw that. Blount County convictions were 2 B felony convictions in 1999, one of which being the possession of a Schedule 6. I'm sorry, that was a misdemeanor conviction. I apologize. He had possession of Schedule 2 with intent to resell, Class B felony, and possession of Schedule 1, Class B felony. So those were in cases out of Texas. The first one was possession with intent to distribute cocaine and marijuana, and the second one was attempted possession with intent to distribute cocaine. And so for purposes of the statute as it existed in 2000 when he was convicted, the statute states that, again, the issue that we ran into here was the judgments in the federal cases don't actually list a specific drug quantity. And so we have been going round and round with the district court in Texas. The only way that we could get something that specifically stated the drug quantity was in their version of a PSI, which is sealed. And I even had an AUSA out there attempt to file a motion to get it unsealed. That was not fruitful. So while the state cannot say a specific quantity as it relates to these convictions, when we look at the statute as it existed in 2000, and it's really the same language even today, basically. At a minimum, the sale of any amount of Schedule II cocaine would qualify as a Class C felony. And so the state contends that we have the Class B felonies in Blount County, as well as the federal convictions that at a minimum would qualify as a Class C felony under Tennessee law. And so we would ask the court to find that he is in fact a Range 2 multiple offender based on those.
May it please the court, this is a quintessential example of why Tennessee courts and statutory law require a finding beyond a reasonable doubt. TCA 4035-106A1B5 provides, when classifying prior out-of-state convictions to determine sentencing range, elements of out-of-state offensives must be compared to Tennessee law as it existed at the time of the prior convictions. Not as the law currently exists, citing in the commentary State versus Brooks, 968 Southwest 2nd, 312, 1997. What the issue is before the court, one, in drawing on our experience, and I would ask the court to draw judicial knowledge in terms of being a federal practitioner and dealing with the pre-sentence reports, they do not contain the elements of the crime. The judgment for federal judgments, as you can see here, are very formalistic and do not contain the elements of the crime. One thing that's very important, when you look at the issue of separate sovereigns, you have the federal forum, you have the state forum. At the heart of the charges is quantities. Federal drug cases begin, end, and are driven by drug quantities. That's why the state sought an AUSA who tried to unseal some of the information. That AUSA reached out to my office. We did not agree to unseal the pre-sentence report. So we would respectfully submit that without information regarding the elements of the federal offense compared to the elements of the current Tennessee offense, as it existed at the time, it would not be an appropriate enhancement factor under 4035-106A1B5 and also under State v. Brooks. But quantities are very important. Quantities under federal law have changed regarding DOJ policies, administrations, whatever. Tennessee law is driven by minimums and whatever. So the fact that the state tried to get the information and was not successful shows that they know they need more. And again, if he's range 1, that's still a very significant range for what Mr. Paschal is convicted of. But we would respectfully submit that unless the state complies with the letter, not the spirit, the letter of this. And that's why when we have issues with federal cases and state cases in terms of trying to get people writted, trying to do this, it's a very cumbersome process. And if at the last minute you say, hey, I need this unsealed by a federal court, that's not the way it works. I mean, there would probably have had to have been an appearance from someone here or someone appearing pro hoc vici on behalf of the Knox County Attorney General's office in that federal forum seeking to unseal the records and getting those certified. But that state has not met the requirement as articulated in State versus Brooks. We think that should not be considered as a applicable enhancement factor, and that Mr. Paschal should be range 1.
Could I please withdraw those judgments? Thank you. Give me just a second, please. And I guess also the Blount County judgments as well. Thank you. This is a somewhat different issue, but I do want to ask, I'll ask Mr. Isaacs first, and then I'll ask General Good. I'm not seeing anywhere in here where it says the date of the offense. Have you found that in here, or do you know that it's, I'm talking about the federal judgments. I know that's listed in the state judgments.
No, sir, because that would typically have been contained in the indictment or the criminal complaint in federal court.
I see. Okay, very well.
I do have those documents.
Well, I'm not sure. I'm not necessarily sure that it is. When you say you have the documents, you mean the complaint?
I have the indictment.
Are they certified?
I pulled them off Pacer. No, those
They're
probably
not
are not.
certified.
But
They're inadmissible. Okay, I just had that question. The state does carry the burden of proof beyond a reasonable doubt as to sentencing range, so I will give you the last word on this particular argument if you want it.
And Judge, I would just note, as far as because I kind of thought that these might relate to the Blount County cases as well initially. If you will look on the Blount County, the date of offense there, I believe, is 1997. We do have the date that the offense concluded on the front of the federal judgment. The federal judgment has an offense date conclusion of 2000, if that clarifies it all.
Oh, I see that on the face of it, yes.
Yes. So.
I don't know how I missed that. It does answer my question.
No worries.
Any further argument as to this issue, General?
No, Your Honor. The last thing we would say is just that we do not believe that a specific quantity is necessary. I did try and get that just for, to see if we could make it a little bit easier. But nonetheless, like the statute plainly says in 2000 and even today, the possession with the intent to resell cocaine in any amount is at a minimum a Class C felony. And so we would ask the court to find that he is arraigned to.
And you're saying that the attempt would be a D?
I think the attempt would be a D, yes.
Which could go up 2 classifications to catch the B, aggravated kidnap?
Yes.
Okay. I gave her the last word, Mr. Isaacs, but it looks like you have something.
You did, and I tried to sneak out.
This is an important issue, so if you have argument on that, I'll allow it.
And I think the court, for your careful consideration, but just simply, that's not enough to make the determination. What we have before us here in a federal case, and that's why they tried to unseal it, and the federal judge said no. And again, the standard's beyond a reasonable doubt. That's why we certify things here, in Tennessee. That's kind of archaic, kind of like the old wax stamp and whatever. But there's not enough to make the required finding when you compare the elements and the ranges, because we're guessing at things as we're talking. And I don't mean guessing in a deprecating way to the court.
Yeah, I understand.
But again, range one is significant, but this would just add another potential issue for appeal. If the AUSA would have unsealed everything, I would be sitting right there politely listening. But we don't have the appropriate records before us, and we would ask that he be range one.
Thank you, Mr. Isaacs. General, anything else?
No.
Okay. This is something, usually when I have a sentencing, I rule upon the range along with everything else, and it's generally not in dispute. It is in dispute here, and there's a very big distinction depending upon which way the court rules. I think it is important for the parties to know my ruling on that issue before they argue the remaining things that we need to discuss today, the application enhancement, mitigation factors, and anything else along those lines. So I hate to take a recess to do this, but I think this is an important question. I do want to go back in chambers and look at this a little bit before I make my ruling. I appreciate everyone's patience. I know you've hung with us all day here today, but this is an important question that we need to resolve in the correct way. So I'll be briefly taking the issue under advisement. Court's in recess.